Simon, Lenny, prayers pastor.
Joseph Ngware. Simon Mulenda. Yes.
I appear alongside Mr. Malicious, Mr. Bushiri, and Mr. Koenda for the respondents' suspects.
Kapramayaka.
Yes, Your Honor.
Do you have something else to add other than what you have stated in paragraph 15 of your affidavit?
I don't have.
You don't have.
That's all I have.
Okay, so, so you do have something to say?
Yes, Your Honor.
Just sit.
It's okay. Though I prefer speaking when I'm standing,
But
because
now,
of space.
how are you going to stand? I am seeing you being thrown
Yes.
over.
Because of space, I'll just sit. Yes, the application by the investigating officer is brought under Article 49(1)H of the Constitution.
49(1).
49(1)H of the Constitution. He's seeking to have the two suspects detained for a period of 21 days as he conducts his investigations. That article requires him to give compelling reasons why they should continue to be detained. We'll be asking you to consider the reasons given under paragraph 15 of the IO's affidavit. And also, Your Honor, looking at the application and the affidavit, we would like you to consider that he's investigating into serious offences that were committed during the protests on the 25th of June this year. Particularly the extensive destruction of property that was caused in Molo sub-county, to which the suspects herein have been linked in preliminary investigations. There was also, from the application, we also note that there was a conspiracy involving the suspects to cause destruction to the Molo police station, the sub-county offices in Molo, as well as the judiciary premises in Molo. But, Your Honor, their efforts were thwarted by the police, who managed to overpower them. The first suspect is said to be the MCA Molo ward, and the second suspect is said to be his assistant. By virtue of the offices they hold, we consider them, and I ask this court to consider them as persons having influence. The key witnesses in this case are expected to give evidence of financing by the two suspects to commit various offences, as have been indicated in the application, during the protests. That is why the investigating officer needs these people in custody, as there is a great likelihood that they may interfere with witnesses, key witnesses. I'd also like to refer the court to section 123A, 1 of the Criminal Procedure Code, which mandates this court to consider the nature, the circumstances of the offense that are alleged to have been committed, and also the position held by the suspects. In considering those two areas, we urge this court to consider in denying the suspect's bail at this stage. We also urge the court to consider the complexity of the investigations that are being carried out. The investigating officer is required to obtain statements and evidence from members of the business community in Molo. The sub-county, Molo sub-county, as well as various witnesses who are not from the Molo locality. the investigating officer is also looking into a wide range of offences. And it is clear from his affidavit that the apprehension on our part is that these witnesses, the suspects, there's a great likelihood that they would interfere with the ongoing investigations. So I pray that the officer's application be allowed.
Okay. Lead counsel.
Yes, Your Honor. Thank you. Your Honor, we should briefly address you regarding that application. Your Honor, we strongly oppose that application. And before even getting into the merits of the application, there is a preliminary issue, and it's good that Mr. Harrison Mayake is present. Perhaps with your direction, he can confirm whether he appeared before Commissioner for Votes and had his affidavit in support of his application commissioned. If he appeared, we can proceed from there in opposing the application. We can just confirm that he is present and which commissioner should he appear.
Suggesting that we deal with the application first, since that was where we started. If it was just a minute.
It touches on it, and Counsel had been given her time. Perhaps if he responds, he can see where his argument is going.
I think if he had a preliminary objection, we would have begun with the objection.
It is not a preliminary objection. It is a preliminary issue in the set of issues that are before the law. You can just say so yes or no.
Your Honor, being assisted by the body people here. Being assisted by the body people here. Because of time, I was busy in the station going on with processing of the suspect. I left the affidavit with the clerk who assisted me with this lawyer.
So you did not appear before any commissioner?
Yes, Your Honor.
So, Your Honor.
Just a minute. Let me record that, right?
Yes, yes.
You can continue with your objections, then so here will respond. The DPP's office here in Nakuru or in Molo? In Nakuru. Yes. So, Mr. Okero.
Yes, Your Honor, the application before you is fatally defective. And we say it's fatally defective because it's unsupported by facts. Your Honor, you've just confirmed from the person who has sworn the affidavit in support of the notice of motion that he did not appear before any commissioner for audits. So there is no affidavit in support of the notice of motion because whatever is there offends the provision of the Oaths and Statutory Declarations Act. He was supposed to appear.
I know I write fast, but not fast.
Okay.
The offense the provisions of
the Oaths and Statutory Declarations Act. Because, Your Honor, under that act, a person who swears an affidavit is supposed to appear before a commissioner for oaths in person, Your Honor. You've just been told that did not happen in this instance. The second peculiar thing, Your Honor, I urge the court to take judicial notice that there is only one advocate in the entire Republic by the name B.E. Owino Oenga. B.E. Owino Oenga. And by coincidence, Your Honor, that advocate is here before you, representing the respondents who are the accused persons hearing. So it cannot happen that advocate for the respondent is the one who commissioned an affidavit aimed at detaining his client. Your Honor, for record purposes, yesterday, which was the 3rd day of January, I, alongside Mr. Oenga, visited the accused persons at Central. Yesterday, 3rd of July, 2025. I and Mr. Oenga visited the accused persons at Central Police Station. And for the record, Your Honor, and again I urge the court to take judicial notice of this. The first accused person, until last week, Your Honor, until 2 weeks ago, he was the Deputy Speaker for Nakuru County Assembly. Your Honor, he was impeached, and after his impeachment, I, appearing alongside Mr. Gatitu, Mr. Oenga, and Mr. Mushiri, we filed judicial Nakuru High Court judicial review number E006 of 2025, where even when you go to the CTS, it will show clearly Mr. Oenga is advocate for the first accused person. Your Honor, an application seeking to deny a person the right to liberty must be founded on facts. Now we don't have a supporting affidavit. All we have is a notice of motion. So there are no facts to back up the application that is before. Nonetheless, Your Honor, now we can go direct and address the application. Your Honor, in this application, what the court is being asked to do is to interfere with the right of liberty of the two accused persons. Right of which, Your Honor, is enshrined on the Bill of Rights. Is one of the rights under the Bill of Rights, Your Honor. It is not an absolute right, we agree. But for it to be interfered with, Your Honor, the prosecution has a duty not just to give reasons why the right should be interfered with, but compelling reasons. There's a difference between reasons and compelling reasons. These reasons, Your Honor, should have come in form of an affidavit, which is not there. The affidavit on record is incompetent. It cannot amount to an affidavit. It cannot support the instant motion. Your Honor, it is our submission that the instant application is a desperate measure, Your Honor, by the police to be seen to be working, Your Honor, especially in light of the protests that happened on 25th of June 2025. Your Honor, as it has been stated in the notice of motion, whatever the accused persons are being accused of over here are said to have happened on 25th of June 2025, and today,
The protests were on which date?
25th of June 2025, and they were national protests, not just in Molo.
So they are being accused of?
Whatever they are being accused of, the stealing, arson, allegedly happened on 25th of June 2025, and today is the 4th. Today is the 4th of July 2025. So the prosecution has had 9 days to investigate this matter. Your Honor, again we submit the rule of the thumb in criminal proceedings is that you investigate first, then you arrest. You don't arrest, then seek to investigate. But now they want to arrest, detain them in custody, as they purportedly now investigate. Your Honor. You know, you've not been told what they have done for the past 9 days. Your Honor, again, referring to the bond and bail guidelines. Yes, again, we state that right to liberty is not an absolute right. There must be compelling reasons, and the bail and bond guidelines, Your Honor, have stipulated factors to be considered by the court, Your Honor, in deciding whether or not to grant suspects bail or not. The number one factor, Your Honor, and which has been mentioned, I won't refer to the affidavit since it's incompetent, but it's been mentioned in the notice of motion, is that whether the accused person can interfere with witnesses. Your Honor, not even one potential witness has been mentioned in that notice of motion or the supporting affidavit. Not even one. How then, Your Honor, will the accused person interfere with a witness that he does not know? Number two, Your Honor, you've been told that witness statements are yet to be recorded. Your Honor, the accused persons are not police officers. They play no role in recording of witness statements. And, Your Honor, the prosecution has not shown us how, if the accused person is not in custody, the police will be unable to record statements from the unknown, unnamed witnesses. Number two, Your Honor, is whether the accused person is a flight risk. Honor, the accused persons are not flight risks. The first accused person.
Objection, Your Honor. We did not raise the issue of being a flight risk.
It is part of the bond and bail terms.
But
that is submission on a matter of law. That is submission on a matter of law. Your Honor, flight risk must be considered. Your Honor, we say that.
You are raising it as a matter of law, proceed. Yes.
Your Honor, the first, as you've been told by none other than the prosecution, the first accused person is the MCA. Is the MCA for Molo. And the second accused person, Your Honor, is his personal assistant. They have known abodes in Molo. And even the first accused person comes to the National Assembly, the County Assembly every week. He's not a flight risk. He is available. The office of the MCA is a public office in Molo. He is there weekly. He is not an accused person. There is no reason to detain these people. Your Honor, number two, you've been told about purported powers that are wielded by the accused persons. Case in point, the second accused person is a personal assistant to an MCA. Which power, Your Honor, does he wield such that unless he is detained, investigations shall be interfered with? Your Honor, it is our submission that the prosecution have each and every right to carry out the investigations that they want to carry out in this matter. But as they carry out those investigations, let them not interfere with the right of liberty of the accused persons over here. Your Honor, the accused persons are ready and willing to abide by whatever bond or bail terms shall be given by this honorable court, including, Your Honor, presenting themselves to the police station as and when they are required. They shall remain ever available. I wish the prosecution had even named one witness, one potential witness, so that the accused persons could have undertaken not to even go near such a witness. But as at now, there is no witness, there is no complainant. We've been told about the issue of, when you go to paragraph 15 of the notice of motion, we've been told that the life of the accused persons is at risk. Your Honor, the accused person have never complained in any police station that their lives is that their life has been threatened by someone, warranting them to stay in custody for 21 days as the purported investigations are being carried out, Your Honor. So that, Your Honor, it is our prayer that you dismiss this application and admit the accused persons to bond or cash pay, including even a free bond, Your Honor. They are willing and ready to avail themselves anytime they are called upon. If we still have time, Your Honor, my co-counsel can address you, that's all.
Yes, Your Honor. Just to add Mr. Gatito, just to add cherry on top of what counsel has apprised this court, I also vehemently oppose the said application for reasons that, Your Honor, at the very outset of Article 49(1)(f) of the Constitution is very categorical. An arrested person has the right to be released on bond or bail terms unless there are compelling reasons. No compelling reasons have been demonstrated by the prosecution. Your Honor, what is before this court is speculative, vague, and unsubstantiated allegations. No documentary evidence has been adduced, just general allegations with no specific linkage to my clients, Your Honor. Was still, Your Honor, they were arrested on the 3rd of July, 2025.
3rd of July?
Yes. Held without any charges, no disclosure of any offense, and no holding charge. Your Honor, this is a direct and continuing breach of Article 49(1)(a) Roman 2, 49(1)(f), 49(1)(a) Roman 2, 49(1)(f), and Article 25 of the Constitution. Your Honor, just as Mr. Okiru has apprised this honorable court, It occurred on 24th June. The said allegations. No action for 9 days. And they only chose to arrest the suspects on the 3rd of July 2025. Your Honor, this timing speaks volume. It betrays a political motive.
Ni arrested someone?
3rd of July. The timing speaks volume, Your Honor. It betrays a political motive to punish and not a legal process to investigate. Your Honor, that is not the law. That is persecution and not prosecution, Your Honor. The supporting affidavit makes numerous accusations, but there is no evidence to that effect, Your Honor. More allegations in an affidavit do not amount to evidence, Your Honor. Your Honor, what the court is being asked to do is to suspend the liberty of the suspects on the basis of speculation and to buttress this position, we rely on the miscellaneous criminal application number 304 of 2016, where, Your Honor, it was held that liberty is precious and no one's liberty should be denied without lawful reasons and in accordance with the law. Your Honor, the absence of liberty causes a sense of emptiness. Your Honor, the first suspect has a medical condition, specifically allergic airway disease. If the court permits, we can furnish them with a copy of the same.
What are you giving us?
It's a medical report. As Okiru apprised this honorable court, the suspects are not at flight risk. They are not going to interfere with any witnesses. In fact, during the arrest, they voluntarily accepted to be arrested. Your Honor, the suspects are fathers. Your Honor, detaining suspects as an investigative shortcut is unconstitutional. And in conclusion, Your Honor, the application is a veiled attempt to intimidate and punish leaders and to trample on the presumption of innocence. That said, Your Honor, we pray that the application be declined and the release of the respondents on reasonable bail terms. Thank you, Your Honor.
Your Honor, Moshiri, for the suspects. My colleagues have rightly placed forward the nature of the subject application and the affidavit, which I reiterate that it is null and void ab initio. Secondly, Your Honor, the subject application by the prosecution is attempting a pre-charge detention of the subject suspects. And I'd like to invite this court to rely on the High Court Criminal Revision number 208 of 2020.
208 of 2020.
Yes, 208 of 2020, which brought forth and which broke down a situation where the prosecution has to present compelling reasons in order to warrant a pre-charge detention as they are seeking now. We further urge this court not to be swayed by the weight of the subject prospective charges or the political climate which is actually surrounding this issue. The suspects are entitled to the presumption of innocence, and there are no compelling reasons that will justify denying them their constitutional right to liberty at this stage, Your Honor. Therefore, the subject application should be dismissed.
It please the court, yes. In the matter, my name is B.E. Owino Oenga.
I know you as Mr.
Yes,
Owino.
you know me as Mr. Owino. Finally, you know my other name.
Now I know your four names.
Now you know my four
E
names.
stands for? E stands for?
E stands for Elisha.
Elisha.
Yes, given that my other name is stemmed from the Bible, our God is a God of wonder. It appears that I have commissioned an affidavit against my own client. I wish to confirm no one has appeared before me today to commission any affidavit in support of a defective notice of motion. I have been...
Slowly.
Yes.
You wish to confirm that?
I wish to confirm no one has appeared before me this morning to commission any document in support of any application. I have actually been engaged in a mediation matter number 36 of 2025. In fact, it is currently ongoing at the Advocates Lounge. I rushed here to be ready to start saying, you know, our criminal justice system is not only punitive, it is restorative and it is reconciliatory. I want to refer to paragraph 9 of their notice of motion that I know is defective, where they are saying that there was an impeachment of the first respondent, and due to that some things happened on the 25th. Now that this is a politically motivated cause, when now do we cite reconciliation and restoration? Let us cool down the temperatures. We know the temperatures are high in this country. As I wish to confirm that our criminal justice system is reconciliatory and restorative, I wish to implore the state agencies, in the words of the famous Rigi G, we shall not manage politics with the criminal justice system. During his inauguration, he said that many times, and he keeps saying it, and I will repeat it. Let us not manage politics with the criminal justice system. Like I have said, it is restorative and it is reconciliatory. It is not meant to punish. Lastly, there is a presumption of innocence until guilt is proven. Why do we want to delay admitting that there is actually a presumption of innocence until guilt is proven? They seek to hold someone to continue investigating. That is an administrative delay. Why should a person's right to liberty be denied because of administrative delay? It is wrong, it is unwarranted, it is uncalled for. My colleagues who have spoken before me have captured almost all the limbs that I wanted to talk about. So I will digress by saying this is a court of equity. This court ought to do that which ought to be done. And I know we are appearing before a seasoned court we will be expecting a seasoned ruling. We are most obliged.
That's all in our part, Your Honor.
So, I'll be asking this court to appreciate the nature of the investigations being carried out by the investigating officer. He's looking into offences that were committed, several offences, including arson, malicious damage, stealing, among other offences that were committed during the protest. And the issue has been raised concerning the investigator's affidavit. And while the counsels are raising issue with the commissioning of the document, I have not had any issue being raised as to the content of that affidavit. The officer is present in court. He can make the amendments on oath. And the defense have not requested for any opportunity to cross-examine the investigating officer on the content of this affidavit which is filed before you. So my argument, Your Honor, is that let us not be swayed by technicalities, but by the substance of the application that is before you. Yes, and the officer is in court. Should the court, if the court would like to inquire anything as to the contents of the affidavit, he can be placed on oath and examined on the same. So the defense has tried to raise other issues, making political, indicating, trying to indicate that this case is has political influence. I'd like to reiterate that nothing to that effect has been raised by the investigating officer in his affidavit and his application. He's not investigating into the circumstances of the JR application or the impeachment of one of the suspects. His investigations are limited to the offences committed on the 25th of June, 2025. The main issue that we have raised, the issue of interference with witnesses, is a compelling reason, not just a reason, a compelling reason not to have the suspects out on bond. And from the application, it is indicated that the two suspects were seen handing out money to groups of youth who we expect to be called as, to record their statements as witnesses. Being in positions of influence, it is very evident and a great likelihood that they will interfere with these witnesses. in such applications, Your Honor, it is not mandatory that for the investigating officer to provide the names, considering that the case is at investigative stages, and also to protect the identity of these witnesses. It is not mandatory that their names be published in the application. Once the matter is concluded, discovery will be done at the appropriate time if and when the decision to charge is made against the suspects. We'd like the court to appreciate that the matter is still at investigative stage. We'd also like to confirm that investigations have been ongoing from the date of commission of the offense. The suspects have been availed in court within 24 hours of arrest. Therefore, their rights as arrested persons have not been breached in any way. And that is why we are here before you under making an application under Article 49(1)H for their extended detention. So we request that you allow this application to preserve the integrity of the investigations that are ongoing, which, as we have demonstrated to the court, are quite extensive. That's why we have requested for 21 days. That's all, Your Honor.
What do you say to the issue of the competence of the affidavit?
It's not fatal. I addressed that first, indicating that it is not fatal. We have the officer before you, and his averments can be put to cross-examination. We have requested the court to consider the substance of his application.
Okay. Good. Is whether the suspect should be detained for 21 days as requested by the investigating officer. The applicable law was aptly captured by the prosecutor and defense counsel in their respective submissions. The question I ask myself is, does the law as applied to the material availed by the investigating officer and the prosecutor in urging for a pre-charge detention for 21 days favor granting of the application? The first objection was with regard to competence of the affidavit in support of the application. The defense counsel contended that the deponent did not appear before any commissioner for oaths for swearing of the affidavit. The deponent of the affidavit confirmed in open court that indeed he did not appear before any commissioner for oaths. The effect of an affidavit that has not been sworn before a commissioner for oaths, who is mandated by the Oaths and Statutory Declarations Act to administer oaths, is that the substance of the averment is of very low probative value, if any. More evidential material is required to support the averments not made on oath in order to prove a fact in issue. The affidavit was not supported by any documentation. The prosecutor implored on the court to find that an alleged likelihood of suspects with interfering with witnesses and ongoing investigations were compelling reasons to deny the suspects bail or bond. From the bar, it was indicated that by the prosecutor that the suspects were seen handing out money to some youth who are expected to be called as witnesses. Further, being in positions of influence, there is a great likelihood that they will interfere with the witnesses. The alleged offences were committed on 26th of June 2025. The suspects were arrested on 3rd of July 2025, If the suspects were the sponsors of violence and were seen handing out money, that must have been before 26th of June 2025. The investigating officer had more than 7 days to arrest the suspects, and had they been arrested on the day they were seen handing out money, or the day of the protest, or even a day or two later, one would believe the narrative of likelihood of interference with witnesses. Making an arrest 7 days later and allege possible interference with witnesses is self-defeating because the witnesses, if any, must have been interfered with by now. No believable or credible evidential material was available to this court to confirm that since the suspects are sitting member of County Assembly and his assistant, they wield so much power as to interfere with the witnesses they have or would have had contact with 7 or so days ago. Furthermore, the numerous witness protection measures that have been provided by law, including the Witness Protection Act, which the investigating officer could apply in protecting his potential witnesses if he feels those witnesses might be interfered with. I say this because if the suspects are as powerful as this court is being made to believe, they could easily use other people to interfere with those very witnesses. In my view, there was absolutely no credible, believable material available by the investigating officer and the prosecutor to demonstrate that the suspects are a danger to community or business, or that their lives are at risk. That witness statements or non-locals have not been recorded cannot form a basis for denying a suspect their right to liberty. Nothing has been placed before the court to show that the suspects will in any way stop the investigator from recording the statements at his convenience. In the end, I find no compelling reason to warrant continued detention, even for another minute, of the suspects. The investigating officer has had 7 days to investigate before arrest and must have had sufficient evidence to charge the suspects, hence the arrest. A pre-charge detention at this stage will only serve the purposes of violating the suspect's right to liberty and presumption of innocence. This court will not aid the investigators and the prosecution in such an endeavor. Both suspects are released on personal bonds of 50,000 each. They shall be reporting to the investigating officer at such times or days as the officer may require them to do, and those directions by the investigating officer in this regard shall be reasonable and capable of being complied with. That's my view.
Thank you. Thank you.
Tupate na ustawi. Solidarity forever. Solidarity forever. Solidarity forever. Community power. Community power. DCP power. DCP power. Arambe.
Ni